Islamic law, according to the traditional view, does not assign a financial value to pure rights. A simple example of pure rights is the payment of earnest money in a contract of sale of property, the payment of goodwill of a business, payment for exercising an option at the commodity and stock exchanges, and so on. Intellectual property rights are pure rights that are deemed property in the modern world, but they are utilized through the exercise of a right, there being no physical or tangible property. A well-known right is called copyright, or the right to sell one's expression, where expression is not tangible. The position of Islamic law on this right may be explained through an example from the Hidayah. The Hidayah says that if a person steals a book, his hand will only be cut for theft if the value of the paper and ink used in the book exceeds the nisab determined for the offense of theft. In other words, the intellectual content and expression in the book has no value for working out the nisab or relevant value. We may add that the denial of financial value to pure rights is built into the entire Islamic law, and acknowledging a financial value for such rights will require the alteration of many fundamental rules of this law. Modern scholars, ignoring such fundamental issues, have declared pure rights, and hence intellectual property rights, to have a financial value. Their reasoning, when they provide it, is weak, but their view has received general recognition, and intellectual property, in its various forms, is being treated as marketable wealth. If intellectual property has been declared marketable wealth or property that yields returns, it must be subjected to zakat. Muslims all over the world own such property and are dealing in it as a lawful source of funds since decades, if not a few centuries. Are they paying zakat on this form of property? Probably not, but they must. To understand the nature of such property and to identify intellectual property that will be subjected to zakat, we may provide a list that is by no means exhaustive. The first category of property to be listed is called copyright. This will include literary, artistic, and scientific works. It will also include published editions, films, sound recordings, broadcasts, and the like. The next category is that of patents that will include innovations and inventions in lighting, smartphones, and numerous other fields. This category is followed by trademarks, which are signs used for identifying various products and commercial goods. There are other forms of property too, like trade secrets, industrial designs, and geographical indications. A complete description of such property will make this video lengthy, which reminds us that YouTube videos will also be included in this form of property. What then is the rule of Islamic law for such property for purposes of zakat? This form of property is first included in trading goods in general, and then linked to a specific form of trading good called rental property. Like rental property, all yields from intellectual property must be subjected to zakat immediately upon receipt of a yield at 2.5%. The assumption is that a year has already passed on such property, after which it is yielding growth in the form of returns or rental value. In addition to this, if this intellectual property is sold, like selling the copyright or a patent to someone, the sale value will be subjected to zakat, but this value will not be subjected to zakat before sale. The conclusion then is that all returns on videos, films, patents, industrial designs, and the like are to be treated as rent and not as income, just as a house or building is subject to zakat through its rent. It is also compared to debt receivable, or debt that is to be received from the debtor as a whole or in parts. Zakat is to be paid on the debt amount as it is received. It is assumed that debt is property lying in deposit with someone on which a year has passed. Zakat is paid on the amounts received from the debtor. Zakat on intellectual property will be treated in the same way. The video or books or any other form will be assumed to be property not received as yet. The haul or year is assumed to have passed on such property. As the returns are received, they will be assumed to be part of the property that was on hold with someone, and these returns will be subject to zakat. This is the first stage of paying zakat on intellectual property. The second stage may be compared to an additional house meant for sale, or a plot of land bought for later sale and profit. Zakat on such property is not to be paid every year because it is not activated property. Activation of such property takes place when it is brought to the market and sold. Zakat is, therefore, paid on the sale amount. Intellectual property, when it is lying around yielding returns, is not subject to zakat each year. It needs activation, which means it needs to be brought to the market and sold. Once it is sold, zakat will be imposed on the sale amount.